Greetings everyone, welcome to the maiden edition of the Nabila show on Muftau Nabila Abla YouTube channel, your home of exclusivity. 31st July happened to be exactly 1 year since I published on my blog mufnabila.wordpress.com that the now defunct normalization committee were planning to disqualify Wilfred Kwaku from contesting the 2019 GFA presidential elections. I stated in my publication that they were going to use two things to disqualify him. One of them was his decision to go on public radio and talk about why Ghana failed to qualify for the 2018 FIFA World Cup in 2017. What he said in that radio interview was that the government of Ghana, to be precise, the Ministry of Youth and Sports, expunged a certain area in their budget which was meant for unclassified or indemnity payments. And according to him, it was one of the reasons why Ghana failed to qualify for the 2018 FIFA World Cup. The other aspect that they were going to use to disqualify Palmer from contesting the elections was that they got in touch with a private lawyer in the person of Frank Davis of the Davis law firm to write to Palmer in April 2019 asking that he makes available 10% from the transfer fee of his player Joseph Pencil, who was playing in Hungary before moving to Belgium to continue plying his trade. Wilfred Kwaku did not make available the money despite signing an undertaking that he was going to make the payment. However, one thing was clearly stated in Wilfred Kwaku claims that it was on the condition that the Ghana FA were going to help him transfer the player by making available his ITC. Unfortunately, the GFA did not play their part in helping him transfer the player, so he was also reluctant to make the payment. His other reason was that if the GFA actually wanted that a member of the association or an official of the association makes payment to the Ghana Football Association, what they should have done, per his understanding, was to let the secretariat write to him, and if he misconducted himself, then they would refer him to the disciplinary committee. He said he didn't understand why they were engaging a private lawyer to write to him. These were the key things the normalization committee relied on to disqualify Wilfred Kwaku, as I published on October 4 when they wrote to tell him that his quest to become the president of the Ghana Football Association was unsuccessful because he didn't pass the mandatory vetting process, and that the Wilfred Kwaku had few periods to appeal the decision because they created that lacuna for people who were aggrieved to appeal the rulings of the normalization committee, which was acting as the elections committee. The appeal to the elections committee was unsuccessful. So what happened was that Wilfred Kwaku decided to proceed to the Court of Arbitration for Sport, and that is where I'm going to center my conversation on. On that fateful October 11, in a 114-page document that is in my possession, he clearly enumerated why he felt that the normalization committee, which was acting as the elections committee, acted based on the conflict of interest. He claimed they were biased against him. He also noted that the very articles they were quoting that he violated in the books of the Ghana Football Associations were misapplied by the elections committee. He asked the Court of Arbitration for Sport to give him four things. One was to order the GFA that their decision to disqualify him was null and void. The second thing he also asked from the Court of Arbitration for Sport, he told them that he wants them to order a re-election, and the other one was to say that if they proceed to organize the elections without him, they should declare those elections to null and void. He applied for a provisional measures, but those provisional measures were not given by the Court of Arbitration for Sport. What did the normalization committee say? What did the lawyers of the elections committee say? That is where I am going to be bringing to you in this maiden edition of the Nabila show. Like I've stated a couple of times, this show is mainly to bring you exclusive content. Now, let's go to what the Ghana Football Association told the Court of Arbitration for Sport about Wilfred Kwaku. before the elections committee or the normalization committee or the lawyers of the Ghana Football Association, let's put it that way, because the case is Ghana Football Association versus Wilfred Kwaku Osei. That is how the case is described in the books of the Code of Arbitration for Sport. Before they gave their legal argument to the apex body for sport arbitration in the world, they gave a background of how they arrived at this point. And they clearly stated that the GFA Congress on September 25 adopted a new statutes which were drafted by the normalization committee to be that book that would oversee the affairs of football governance in the country. And they stated that by Article 81 of the GFA statutes, the NC were empowered specifically to act as the elections committee for the upcoming elections. We all know the elections are done, but this defense was sent to the Court of Arbitration for Sport on October 22, just 3 days to the GFA elections. So that is why it is clearly stated in there that for the upcoming elections. And they said, pursuant to these powers given to the NC in the Article 81, the NC formed the vetting committee as part of the organization and supervision of the electoral process. The membership of the vetting committee, as we all know, was headed by Frank Davis, the lawyer who was engaged to write to Wilfred Kwaku on April 30 to ask for, it was April 29, to ask for the 10% payment for the transfer of Joseph Pencil. It was not only Joseph Pencil, it also has to do with Gabriel Lever. For Gabriel Lever, he was going to pay $15,000, but for that of Joseph Pencil, he was going to pay 300,000 euros. That's what he was going to pay to the Ghana Football Association. And they said that when they put together the vetting committee, it was published on the GFA website. So Wilfred Kwaku Osei, whom here has been described as the appellant, they said he was aware of the composition of the vetting committee and that he never raised any concerns or wrote to the NC to object any member of the vetting committee. And they said that the appellant, prior to and during his vetting, did not at any point also raise an issue about conflict of interest, bias, or the likelihood of bias against any members of the vetting committee. They said, in fact, during his vetting, he was asked if he had any objection to the member of the committee on the panel, and he replied in the negative. So what they are clearly saying is that Wilfred Kwaku Osei's decision to write to CAS saying that there was conflict of interest, there was bias, the decision to disqualify him was preconceived and premeditated. They said all these were clearly afterthoughts. That is what the normalization committee is saying, or the Ghana Football Association. They even said that Wilfred Kwaku extolled the work of the committee, and then even the chairman. They said he extolled the virtues of the chairman of the committee, and the chairman there was Mr. Frank Davis. And then they also said that the vetting committee, upon consideration, found that a person who touts himself as a founder, owner, and bankroller, and executive chairman of Tema Youth Football Club, refused to abide by his own undertaking to the GFA in flagrant breach of the GFA rules and regulations adopted at Congress. They said the very institution he wants to head as president, his behavior was unacceptable and in breach of the GFA rules and regulations that has been put in place for members by Congress, thereby failing the high moral integrity test. They said, in his own words, at the sitting of the vetting committee, Mr. Palmer admitted that his conduct and indeed that of his club was inappropriate, and also that with the benefit of hindsight, Tema Youth Football Club should have redeemed its indebtedness to the GFA. Let's do a quick break. When we come back, we'll be doing more on this conversation. I'll be bringing you in detail the defense filed by the Ghana Football Association's lawyer, now Odefole Norte, who was a member of the elections committee, was a member of the normalization committee, the person who oversaw the drafting of the new statutes governing football in the country.
The normalization committee will also act as an electoral committee whose decisions are final and binding, and none of its members will be eligible for any of the open positions in the elections under any circumstance.
A lot have been said and written by us. The Ghana football enterprise is an activity that must be in the hands of the right people.
Very challenging because we find ourselves literally swimming against the tide. We are working in an environment where the press is very negative and not encouraging of our enterprise. In fact, if I am to believe what I hear on radio, you've already written us off. Well, as far as we are concerned, we have even failed.
Colleague delegates, colleague aspirants, like I've always been preaching, football is one big family. In the interest of football, I concede defeat and I congratulate my brother, U.S. Okweku, as the winner.
From our point of view, there's no cause for alarm, because one thing that we all know is that football is run by statutes, regulations. The normalization committee was very, very particular about following the ground rules. We brought in the integrity test. Now, the integrity test is not cordoned off only for Ghana. It is something that is being done all over the world, because FIFA itself realizes that after so many years of maybe not taking this issue seriously, there's a lot of bad things happening all over. And therefore, this integrity test has been put in place. And these integrity tests are objective, based on documents, based on court processes, based on commissions of inquiry, based on judicial pronouncement of the Ghana Football Ethics Committee, Appeals Committee, Disciplinary Committee. All these are documented. Nothing is subjective. And therefore, if we apply this, and it catches some people, and that person wants to appeal, we have no problem with that. But we know in the end, we will win.
Welcome back from the break. It's a pleasure to still have you on the Nabila show. I am Nabila Abdullahi, and I've been bringing you up to speed in relation to the disqualification of Wilfred Kwaku Osei from contesting the GFA elections 2019. And I'm building you up to a decision that will be awarded on the 4th of August. Now let's go into detail and talk about what the Ghana Football Association told the Court of Arbitration for Sport, which is the supreme sports adjudicatory body for world sports. If you have any grievances, and after exhausting all the internal mechanisms, internal judicial processes, you can go to that body to have it addressed if you still feel unhappy with all the decisions within your association. And now let's proceed to their legal arguments, where they told the Court of Arbitration that the Court of Arbitration have got no jurisdiction to hear the matter. They are saying that, one, and this one is from point 17. They say Article 55 of the GFA Statutes 2019 judicial bodies provides as follows. They say the disciplinary committee, the ethics committee, the appeals committee. They proceeded to say that Article 58.5 on the appeals committee state as follows. Decisions pronounced by the appeals committee may only be appealed at the Court of Arbitration for Sport in Lausanne, Switzerland, and or to a national independent arbitration tribunal in accordance with the provisions in these statutes. They're saying that a careful reading of Article 81, which clearly stated that the decision of the normalization committee was final and binding, they are saying that the transitional provisions shows without any hint of equivocation that the drafters of the statutes, and for that matter, Congress, intended to suspend the application of provisions mentioned in paragraph 17 and 18 above. And then they said this position is in line with the very essence of the NC's work, which is a temporary one, to reform, amend statutes, and conduct elections. And then Article 81 of the statutes provide as follows. The members of the Normalization Committee of the GFA shall act as the Elections Committee. This we all know. And they said during the first elective Congress, following the adoption of these statutes and their provisions in their function, so they said that their decisions in that function shall be final and binding. During their term of mandate, the members of the Normalization Committee of the GFA are exceptionally empowered to form committees for the organization and supervision of the electoral process. This I've already stated. And they said the person composing of this committee shall fulfill the independence criteria stipulated under Article 53, paragraph 2 of these statutes. That is what they proceeded to say. And they are saying that based on all these things, they were questioning whether the Court of Arbitration had the jurisdiction to hear the matter. They said a reading of Article 81.2 shows that not only did the statutes exceptionally empower the Normalization Committee to conduct the elections, it also stated without equivocation and or ambiguity that their decisions shall be final and binding. Unlike Article 55 and 58, which categorically stated that appeals after the internal processes have been exhausted can be made to CAS. Article 81.2, which is transitional provision, temporarily outs any form of appeal done to the NC, states that the decision of the NC shall be final and binding. They said the reasoning behind ousting the jurisdiction of CAS, and for that matter, anybody or entity from entertaining an appeal against the NC in its temporary duty is not far-fetched. They said that the GFA Congress recognized that the NC are in their final stages of handing over to the administration of Ghana football to the members of the GFA. So the Congress recognized the members of the NC are not members of the GFA. And as part of these, the terms of their engagement, they cannot hold any office in the GFA. So Congress again recognized that time was of the essence in the conduct of elections, and any setback in the form of appeal against the decision of the NC will have detrimental effect as a body. So clearly, they were stating that appeals were not going to be possible because they didn't want to destabilize the electoral process and calendar of the 2019-2020 football season, because they felt that so many people were going to be affected. Investors in the game of football, they said there was anxiety in the country. They said FIFA and CAF were all expectant about the elections and that they were not ready to entertain such things. And they also told CAS that CAS should not, or CAS does not have jurisdiction to hear the matter. They stated examples. The following decision of CAS, which is 2014 A3775, award of 29th April 2015, 37, making reference to CAS 211 A2436, award of May 2012, and to CAS 209119, award of 7th May 2010, and also CAS 208 A1513, award of 26 January 2009, have settled the dispute on the matter. And they said appeal based on Article R47 of the code, which highlights 3 conditions for CAS to have an appellate jurisdiction. They said the parties might have agreed to the jurisdiction of CAS, that is consent of arbitration. The other thing was that there must be a decision of a federation, association, or another sports-related body, existence of a decision, and that the internal remedies available to the appellant must have been exhausted prior to an appeal to CAS, exhaustion of internal remedies. And that having established in this statement of case that the GFA statutes under Article 1 outs any form of appeal when it is stated the decision of the NC shall be final and binding, they were saying that the question the court needs to confront is whether it has jurisdiction to determine this one. Because they're saying that the question whether a national federation is bound to arbitrate CAS and a dispute with one of its members only because the rules of the general federations to which it belongs recognize CAS as a body to appeal to. So they proceeded to say that the leading decision on this question was decided by CAS panel, and then in code, the panel held that the FIFA statutes do not oblige by which provision for a national federation to allow a right of appeal from its decisions. And they say in any case, if the FIFA statutes did not compel the national federation to provide for a right of appeal from its decisions, no right of appeal to CAS would exist until such a time and the National Federation has made provisions for the right in its statutes or regulations. They say from the foregoing, it is our humble submission that by virtue of Article 812 of the GFA Statutes 2019, the appeal jurisdiction of the court is ousted, and this court has no jurisdiction or right of admissibility to hear the present application, which is pursuant substantive arbitration application, an agreement for which is currently non-existent, because what they are saying was that the GFA did not consent to the CAS hearing the case because the rules of CAS, which is R47, clearly states that both parties must first of all consent to it. Later, somewhere June 22, CAS came out with a ruling that this application was not going to hold water. They rejected it, saying that they've got the mandate to hear the matter. Now let's proceed further. Other things. One key thing they mentioned about Wilfred Kwaku Osei was that they said he was not someone of high moral integrity to head the Ghana Football Association. They also said that he's someone who condoned corruption because he granted an interview to a radio station indicating that the Black Stars failed to qualify for 2018 FIFA World Cup because the government of Ghana expunged what he described as unclassified payments or indemnity payments. So let's take a look at the specific point where they made all these things. I earlier mentioned about how they said that the decision of Parma to go to CAS was clearly an afterthought. Point 35 of their argument clearly pointed out to that matter. And they said, though they have previously argued that the Article 81 of the GFA Statutes 2019, which says the decision of the NC shall be final and binding, this court has no jurisdiction to hear this matter. And they've also said they've demonstrated that the appellant's allegations are only malicious afterthoughts calculated to destabilize the elections, as those allegations have no basis whatsoever. And then they say we have again argued that assuming without admitting those allegations were even true, by the appellant not raising an objection at the time the membership of the committee were made public, by not raising an objection during his vetting, and by not raising these allegations right after the vetting, but only raised these allegations after he was informed of his disqualification, he is deemed to have waived the right to raise these allegations. That is, maybe the lawyers who are watching, maybe they can clearly interpret this better. But on the other side, after this one, lawyers of Wilfred Kwaku Osei also wrote to CAS. They also made their argument, stating why this claim was inappropriate. And I will be sharing that too with you shortly. But now let's proceed to point 36 of the GFA argument. We will be ending the GFA argument very soon because it is up to point 45. The point 45 clearly talks about duly submitted, so that one doesn't contain anything much. So now let's take a look at point 36. We are almost through. They said that the appellant has not challenged the reasons given for his disqualification, but in a bizarre turn of events has rather focused on issues of conflict of interest and likelihood of bias, which have already established in this submission. They said they are malicious afterthoughts. It is without doubt that the reasons for the appellant's disqualification are justified, reasonable, and not arbitrary. The appellant was disqualified on two main grounds, and this is where it gets extremely interesting, because they clearly said that Wilfred Kwaku Osei was someone who condoned corruption. He was someone who preached about corruption. He was someone who was talking about things that are being upheld by FIFA, because FIFA game is fair play, following that radio interview. Now, let's take a read. Point 38. The appellant, as the founder, owner, bankroller, alter ego, and the executive board chairman of Tema Youth Football Club, unjustifiably and dishonestly refused to pay the GFA money due it from proceeds of the transfer of two players. Like I mentioned, I did mention that one player, Gabriel Lever, was also part of it. They said that in the sum of 300,000 euros for that of Joseph Pincio, And the other one was $15,000 for his other player, Gabriel Levert. Many of you remember Gabriel Levert. He was part of the 2017 Under-17 World Cup squad. He was also in Gabon for the African Youth Championship in 2017. So he's clearly a known face. He was transferred for about $150,000. So paying 10% of that money to the Ghana Football Association would have meant that the Ghana FA was going to make about $15,000 from his transfer. And they said his refusal to make these payments, they said they are in breach of Article 33 5C. I just added the C. They didn't capture it, but the regulation, the general regulation of the GFA is Article 33 5C. They said it is a violation of those regulations. And then point 39, they said the ethics committee of the GFA after the 2018 World Cup qualifiers found that the appellant, his comments on local radio stations suggesting that the GFA, and for that matter, the Ministry of Youth and Sports, should have made unclassified payments. They said this is their own definition. Paid certain FIFA officials and match officials unapproved and inappropriate monies to influence the progress of the Black Stars in qualifiers. They said they were unfortunate and demanded he retract and apologize for those comments. They said the essence of what he meant was to compromise FIFA and match officials, a situation FIFA strongly frowns on. Now, let's take a look about the unclassified payments. Unclassified payments per the books of CAF are legitimate. What that clearly means is what I cannot tell. I don't know whether it means to influence referees' decisions. I don't know whether it means to bribe referees. But I clearly think that if unclassified payment is supposed to make a referee comfortable, then you are probably inducing the referee to make decisions in favor of your national federation or your national team or whatever. So I clearly think that unclassified payment shouldn't be something that should be condoned by both FIFA and CAF. There probably should be a different word to it. Unclassified payment, indemnity payments. Where are they? In the books of CAF, somewhere 2017, March or April 2017, or even May 2017, CAF approved $30,000 to be given to each member association to make unclassified and indemnity payments. So in the books of CAF, it is legitimate. But here, the normalization committee said that these are monies which are meant to pay FIFA officials and match officials. They said they are unapproved and inappropriate monies which are meant to influence referees to aid the progress of the Black Stars in the qualifiers. And they said these comments were very unfortunate. Okay. And then they came down to say that the NC was appointed, as we all know. They came into being on September 13, 2018, after the announcer Mayal announced and his Tiger IPI team came up with a documentary. They described it as number 12 in Ghana, but on BBC it was known as Betraying the Game. And some officials of the GFA, referees were all caught in compromising positions. These monies, the announcer and his team claim were meant to induce some officials to do certain things in matches, and most of them have been banned by FIFA, they've been banned by CAF and all that. Well, as to what that clearly the money was meant for, though, because most of them have said that what is being claimed out there was not correct. As to what that was meant for, FIFA and CAF took action against those people who were involved. They came down to clearly mention that the vetting committee therefore held and justifiably so that the appellant, by suggesting, and has already been established by the GFA Ethics Committee, that the Black Stars failed to qualify for 2018 World Cup tournament because the GFA and the Ministry of Youth and Sports refused to pay bribes to influence the outcome of matches or the outcome of games played by the Black Stars. The appellant was not a person of high moral integrity. They say more importantly, right, the appellant during his vetting was asked whether he had been found culpable by the Ethics Disciplinary and Appeals Committee of the GFA, and he told a palpable falsehood that he had not been found culpable. So point 42, in my opinion, was the one that came so hard on Wilfred Kwaku Osei. So they said, it is without doubt that the reasons for the appellant's disqualification were justified and well-founded. It will be unfortunate at this point to put our football fortunes in the hands of persons such as the appellant, who flagrantly violate the regulations of the association he wants to lead and thinks it is acceptable to offer bribes to FIFA and CAF officials to influence the outcome of games. The qualification requirement placed on aspirants, especially to the presidential positions, is designed to avoid putting the GFA in the hands of persons with moral turpitude and lack of proven integrity. It is therefore submitted that there is no likelihood of the appellant being successful in his claim before this court. So, those claims, they say, are baseless, to say the least. Point 43, they submitted to the court that, looking at all the facts they have tabled to them, they said there is no doubt that the interest of not only the GFA, but a good people of Ghana in seeing football return to normalcy, and in the interest of the young and vibrant footballers who have not played any competitive football, competitive league, in the interest of FIFA, in seeing that Ghana football is managed by members of GFA, far outweighs the personal interest of the appellant to become the president of the GFA, they say, at all costs. So they concluded by saying that with this, they are saying that his cause, they've got no merit, and that his request should be declined. After this argument was sent to the Court of Arbitration for Sport, the lawyers of Wilfred Kwaku, headed by Thaddeus Sori, also wrote to CAS and also made some arguments. They pointed out the specific things that the normalization committee of the Ghana FA told CAS. They said the respondent argues that in its response to appellant's application for provisional measures, thus, they said the court has no jurisdiction to deal with the matter. Respondent will suffer more harm. Appellant waive its right to challenge the obvious conflict of interest position in which the chairman of the NC and also the vetting committee constituted by the elections committee had found themselves. And they said the decision of the vetting committee cannot be faulted. The appellant was accorded the right of appeal. Now, let me state one thing very clear in this. The publication I mentioned earlier in my intro, there were other subsequent publications. All these publications are before the Court of Arbitration for Sport. The lawyers of Wilfred Kwaku noted those publications and said that the decisions of the normalization committee were predetermined, premeditated, preconceived. So the claims of conflict of interest that the NC say is non-existent, the lawyers of the FA referred CAS to those publications that I put out in July and September respectively in relation to Wilfred Kwaku and the people the normalization committee were planning to qualify to contest for the GFA elections. So they started pointing out one by one in their argument. They said, as jurisdiction is fundamental, they were going to deal with that one first. Lengthy submissions have already been made by the appellant's legal argument with regard to the court's jurisdiction, but they just wanted to put something in place because they feel that the argument of the GFA lawyers were misleading. And so they're saying that per Article 81(2) of the GFA statute, that we clearly know where they said that it was going to be final and binding and all that. So The argument put out by the lawyers of the GFA was that, how do I appeal to a body that has disqualified me? How am I going to appeal to the same body? It's not as if they had set up a different body who will take a look at the matter and resolve it. And as I published on my blog some few months ago, after Palmer was disqualified, when he filed his appeal, there was no committee to sit down and hear the matter. The GFA called members. Those members came together. The lawyer who is currently acting on behalf of the GFA, then she was a member of the Normalization Committee and the Elections Committee, now the following note. She advised that it should be thrown out. She clearly said that what Wilfred Kwaku brought was an intent of appealing and not an appeal, because Palmer had submitted his documents to the NC at 3:40 p.m. He was given 4 p.m. deadline and he submitted at 3:40 p.m. But what now the Foley told members who attended that meeting was that this was an intent to appeal and not an appeal, so it should be thrown out. So it was rejected per her advice. So if you come to say that you gave the person the right to appeal and it was waived off, and that Article 81 of the statutes were final and binding, the lawyers of the GFA feel that, okay, if you have the power to conduct the elections, and the decisions in relation to the elections shall be final and binding, it is the respondent's case that there is a question as to whether a national federation is bound to arbitrate at CAS a dispute which one of its members only, because whether a national federation is bound to arbitrate at CAS a dispute with one of its members only because the rules of the international federation to which it belongs to recognize CAS as a body to appeal to. They said the question today posed by the respondent is most definitely in the affirmative. The reason is that, do the rules of the National Federation not only recognize CAS, but also provide that parties to the rules of the National Federation may have recourse to CAS? They again noted that respondents refers to case of Cole to justify the submissions and contends that in that case, the panel held that the FIFA statutes do not oblige by such provisions for a national federation to allow a right of appeal from its decisions, and that in any case, even if the FIFA statutes did not compel the national federation to provide for a right of appeal from its decision, no right of appeal to CAS would exist until a national federation has made provisions for this right in its statutes. They said, first of all, they've again noted that the respondent's own rules make provision for appeals to CAS. Further, it is noted that the respondent's reference to the case of Cole is not complete. In that case, the court held that, according to the constant CAS jurisprudence, in order for the CAS to have jurisdiction to hear an appeal, there must exist either a specific arbitration agreement between the parties, or the jurisdiction of CAS must be expressly recognized in the statutes or regulations of the sports-related body. They said, we have noted that respondents' own statutes have always recognized CAS. Article 61 and 63 of the GFA 2019 statute. These very statutes were drafted by Nabila Foley and other members of the Normalization Committee. They said those statutes, Article 61 and 63 of the 2019 statute, recognize the court. So if Article 81 of the statute says the decision of the NC are final and binding, this can only relate to the exhaustion of all internal mechanisms subsequent to which appellant can invoke the jurisdiction of the court. To say the Court of Arbitration, CAS arbitration or appeal jurisdiction to final decisions of respondent are provided for in the statement. They said they are being held final and binding is the basis for invoking the appeal of the jurisdiction of CAS. That's what they are saying. So they cited example. In Tama Youth Sporting Club versus GFA, the appeal jurisdiction of CAS was invoked after the appellant lost the case on review at the appeals committee of the GFA, whose decision was final and binding. They also said final decisions of the FIFA appeals committee in Amos Adamu versus FIFA CAS and Diakite versus FIFA were subject to the appeal decision of CAS. In Kwesi Nyantakyi versus FIFA, the final decision of the adjudicatory chamber of the FIFA Ethics Committee was subjected to the appeal jurisdiction of CAS. So, what they are clearly saying is that CAS have got the jurisdiction to hear the matter. So, subsequently, yes, like I mentioned earlier, on June 22, CAS said it has jurisdiction to hear the case, and that it was going to give a ruling on July 17, and they did not. And now the ruling is now going to be on August 4, 2020. So they explained that CAS have got the power to hear the case after GFA said CAS does not have the jurisdiction. So GFA again went back to CAS and said, okay, well, you give the ruling, you award a decision. But the GFA did not maintain their argument that CAS does not have jurisdiction, despite writing to CAS to give a ruling on the matter. The other aspect that they argued was on whether PAMA was going to suffer more than the GFA, because the GFA said so many people were awaiting the ruling, the elections, so that they could hand over to the new leadership of the Ghana FA. So FIFA, CAF, Ghana, football players, football administrators, people who passed the integrity test were all waiting, and that the GFA stood to suffer more rather than just the individual. The GFA also stated that they spent over about $100,000 on the elections, and that they couldn't have just allowed that to hold on. But the lawyers of PAMA argued that, if we wanted the provisional measures to happen, this usually happens within the space of 2 days, so it wasn't going to be a big deal, provided the GFA wanted it. The GFA never wanted that process, so the CAS did not give a ruling on that matter. And then they also proceeded to make an argument on the conflict of interest bit that GFA said PAMA waived the right to that because he did not at any point raise an objection to members of the committee when it was publicized. He did not raise an objection to members when he appeared before the committee. He did not raise an objection even after. He only waited after he was disqualified before he came out to do that. And they described that as malicious afterthoughts meant to destabilize the GFA election. So the lawyers of the GFA argued that in a situation where conflict of interest is established, the fact that appellant did not raise it is of no moment. They said it is undoubted ground for vitiating any decision regardless of whether it was raised or not by the person affected by it. In any case, the conflict of interest rule having been established as violated, respondent had violated its own rules. They said the established violation of respondent's own rules justifies the setting aside of the vetting committee's decision. This is the accepted practice. That's what they were saying. So they also came down to cite some other cases in relation to Iro versus Bow Street Metropolitan Expedientiary Magistrate ES Party Pinochet. Forgive me for the pronunciation of those words. They said the House of Lords of England invalidated its decision when it was found that one of its judges may have been potentially conflicted. They said the fact that the objection was not raised at the beginning was of no moment. That's the argument. They also said that this is a case in which appellant contends that there is predisposition of bias against him by members of the elections committee, particularly the president of the NC, who also made comments months before the elections on the decision to disqualify the appellant. The allegation of bias against the two members of the vetting committee and chairman of the NC remain uncontested. They said they gave out a pen drive that contains the comments made by Dr. Kofi Amoah that there was already a predisposition of bias against appellant, and which is clearly a violation of Article 2(1) and 3(b) of the regulations of the GFA. They made further argument in relation to the decision of the vetting committee not justified. They are saying that this is a matter for final determination by the court. In any case, appellant has demonstrated in its legal argument that the grounds relied on by the vetting committee to disqualify the appellant are not justifiable, having regard to the qualifications for contesting the applicable position of respondent. They said, we have also noted that the alleged offender is not appellant, but a club in which he serves as official. Article 39(8)(c) of the Respondents' General Regulations gives the sanctions for failing to pay debts and costs to GFA. The sanctions are directed to the club and not an official of the club. The respondent's reason for disqualifying appellant on this basis is completely wrong. That is the argument. Having said that it was completely wrong, they continued that the reason given by the Respondents' Election Committee was that the appellant breached the provision of Article 33(5)(c) of the GFA General Regulations and the decision of Respondents' Ethics Committee. Respondent never stated anywhere in his letter that appellant was disqualified because he was not of high moral standards. This was a clear afterthought. That was also the argument raised by the lawyers of Wilfred Kwaku Osei at the Court of Arbitration for Sport, and they said, under the first reason, the appellant is not Tamayut and should not pay for the sins of the club. Nowhere is it written that debts allegedly owed by clubs would lead to the disqualification of shareholders, directors, or officers of clubs who are interested in contesting positions at the GFA. He said, with regard to the second reason for disqualifying appellant was not convicted or charged by any offense by the Ethics Committee. It was also important noting that they said the 13th December 2017 decision of the GFA Ethics Committee is not a conviction. The appellant wasn't charged with any offense under Part 2, Section 5 of the FIFA Code of Ethics. There was no corresponding conviction under the said provision of the FIFA Ethics Committee. They said they have also pointed out in their legal argument that under the GFA Code of Ethics at the time, the Executive Committee of the GFA reserved the right to approve decisions of the GFA Ethics Committee before the same became effective. So we have also submitted in cases where the Executive Committee considered the said conduct to be reprehensible, the same was referred to the Disciplinary Committee for sanctioning. So they further argued that the ethics decision of 13th December 2017 wasn't submitted to the GFA Executive Committee for approval. Appellant's conduct wasn't considered grievous enough to become the subject of a referral to the Disciplinary Committee for sanctioning. So they are saying that there's nothing in the proceedings which are before the court to suggest that appellant insinuated that the Black Stars failed to qualify for the World Cup tournament because GFA refused to pay bribes to influence the outcome of games or to compromise FIFA and match officials. So at the Ethics Committee, appellant said he meant that the nation could go an extra mile to make match officials comfortable. He cited comforts such as booking of match officials into luxurious hotels or giving them additional gifts on arrival. He especially told the committee that he did not mean that Ghana should pay bribes. The committee found appellant's comments inappropriate and should not be repeated again. They said appellant was also asked to write a letter of apology to the GFA Executive Committee. Appellant was not convicted or charged of any offense. Thus, respondents' allegations against appellant is completely false. So, the appellant right of appeal. This argument even contradicts respondents' own arguments that decisions of respondents' elections committee is final and binding. The purported right of appeal introduced outside respondents' own rules, therefore, is void. In any case, matter has also been well addressed in the appellant's legal argument that was sent, respectively submitted, dated at Sorry Law, Accra, this 32nd day of October 2019. Those were the legal arguments submitted. We all know that, one, when the GFA asked the Court of Arbitration for Sport not to grant the provisional measures, they did not grant them, so they proceeded to organize the elections, where Wilfred Kwaku emerged winner after 3 rounds. Okay, the other aspect of the GFA argument, which said that CAS has got no jurisdiction to hear the matter, this area was thrown out. So you can say 1-1. They've all scored 1-1. But a big matter is the one coming up on August 4. That's where everyone's interest is. Would CAS grant the reliefs asked by Wilfred Kwaku? It's a bit interesting because there are so many people who say that Palmer was disqualified unfairly But there are also others who say, if you really wanted to head an association that your club owes, the onus is on you to ensure that you make the payment. And that comment that Ghana failed to qualify for 2018 World Cup because of unclassified payments, and that he was surprised it was expunged from the budget. I've clearly stated this in one of my publications about Wilfred Kwaku on my blog, mufnabila.wordpress.com. You can always access it there and read. I clearly stated, what is this unclassified payments all about? In as much as it is recognized by CAF, it doesn't mean that payments should not be classified. I don't know whether if it is the English word that I'm struggling to understand, but there's clearly one thing I'm probably missing. Just maybe if I'm to give the layman understanding of what unclassified means, it clearly means that something that is not, like, say, been recognized, something that is not categorized, or should I say something that is not designated, that is not registered, that is not part of. I don't know if my understanding of it clearly means, because this is clearly an adjective that is supposed to provide a description of something. So I get a bit confused when I talk about this clear position. But one thing is clearly interesting. It is the interpretation of CAS that is going to manifest here. Would they grant Palmer's request? The defense put out there by the GFA, was it strong enough? In my opinion, it wasn't clearly that strong. I think that, especially where they spoke about Palmer waiving the right to raise an alarm of conflict of interest in relation, there was one clear thing. There was a publication on 31st July 2019. 4 clear months. The exact reasons I published on my blog were the reasons they used to disqualify him. And trust me, these were not predictions. They were not conjectured. They came from reliable sources. So, was the decision preconceived? I think yes, because I know it was. Did they plan to qualify other members of the old GFA Executive Committee? Yes, because I was reliably told and I published. All these publications were never contested or contended by anyone. And those publications had some of the highest reach on the blog. So it is the interpretation of CAS that's going to reign supreme come August 4. But what would the ruling clearly mean for Ghana football? If they ask for the GFA to organize re-elections effective that day, Code of Sports will lose his position to be the president of the Ghana Football Association. But the executive committee will continue to be there, so they will not have the power to organize the elections for a president. The other thing too is going to be this. If they declare the elections null and void, it means that they organize the re-elections, it means that Curtis goes out. This clearly means that Palmer's integrity questions have been cleared. It means, per CAS's understanding, his actions or inactions were not deemed grievous enough, as explained by their lawyers. But there's another interesting angle people talk about, that CAS would clear Palmer, but Ked would continue to be there as FA president. That's going to be very interesting, because CAS must provide legal argument why they will clear Palmer and Ked will continue to lead as GFA president, or why they will clear Palmer and not nullify the elections. It's a bit interesting, but after the 4th day of August, I'll be bringing you more of some of the things that clearly transpired in the process. But like I stated, 2 of my publications are at the Court of Arbitration for Sport, being used as evidence of a premeditated, a preconceived decision. So let's stand by and have a look at what is going to happen. What would that mean for Ghana football? What would it mean? The hard work put in by Kurt, is it going to run down the drain? The new president, if elected, is he coming to continue the good work? Let's not forget, Kurt might have his own issues of people questioning his decisions to push through statutes of the GFA that members of Congress said, let's accept, let them go so that we'll come and make changes. There's also the other argument that he's violated Article 42 of those statutes, which says that set up an ad hoc committee. That committee will propose to Congress how much should be given to executive committee members as emoluments. Since he came into office, this has never been done. Just recently, he set up a 3-man committee. Wilfred Kwaku Osei rejected that position. But the clear thing is that, yes, now he's moving forward to satisfy that. There's also a Congress coming up on August 27. How does the CAS ruling on August 4 affect that? Whatever happens on August 4 will clearly dictate the new path for Ghana football. It has been a pleasure coming your way with the maiden edition of the Nabila show on Nabila Abla YouTube channel. Thanks very much for subscribing. Whatever feedback you've got, I'm always available to have them. Just drop a comment. You can also have access to my email. Send me a direct email and I would respond. It's been a pleasure coming your way. Thanks very much for your company.
The Normalization Committee will also act as an electoral committee whose decisions are final and binding, and none of its members will be eligible for any of the open positions in the elections under any circumstance.
A lot have been said and written by us. The Ghana football enterprise is an activity that must be in the hands of the right people.
Very challenging because we find ourselves literally swimming against the tide. We are working in an environment where the press is very negative and not encouraging of our enterprise. In fact, if I am to believe what I hear on radio, you've already written us off. Well, as far as we are concerned, we have even failed.
Colleague delegates, colleague aspirants, like I've always been preaching, football is one big family. In the interest of football, I concede defeat and I congratulate my brother, U.S. Okweku, as the winner.
From our point of view, there's no cause for alarm, because one thing that we all know is that football is run by statutes, regulations. The Normalization Committee was very, very particular about following the ground rules. We brought in the integrity test. Now, the integrity test is not cordoned off only for Ghana. It is something that is being done all over the world, because FIFA itself realizes that after so many years of maybe not taking this issue seriously, there's a lot of bad things happening all over. And therefore, this integrity test has been put in place. And these integrity tests are objective, based on documents, based on court processes, based on commissions of inquiry, based on judicial pronouncement of the Ghana Football Ethics Committee, Appeals Committee, Disciplinary Committee. All these are documented. Nothing is subjective. And therefore, if we apply this, and it catches some people, and that person wants to appeal, we have no problem with that. But we know in the end, we will win.